Welcome to the Two Gurus Top Compliance Podcast with me, Kristy Grant-Hart. I'm here with the one and only Tom Fox. This week, we're covering the FCPA executive order that shook the compliance world, the surprisingly gaping disconnect between the C-suite's rosy vision of culture and regular employees' experience, what's going on with New York City Mayor Adams' bribery allegations, and Florida woman's attempt to use Botox to get out of a fraud problem. But first, Tom, how has your week been and what do you think is the most interesting development?
For me, it was leaving the hill country of West Texas when it was 17 degrees on Wednesday morning and flying to Brooklyn where it was warmer. So I'm now in Brooklyn at a creators conference where I'm clearly the eldest person in the entire event. And it's like listening to my daughter and her friends talk. I know, I recognize the words, but I don't know what they mean.
Good for you for continuing your education, though, in this. That takes moxie. I appreciate that.
I made the mistake of, the vibe of the conference is chill. So I was chilling in a session with my eyes closed, and I accidentally raised my arm, apparently as the speaker was asking a question, and he thought I was raising my hand to ask something. So I had to pretend like I was listening to him and ask a question. It's very challenging. So there you go.
Okay, there we are. Tom, I think I'm going to start unusually because I have very big news. Very big news. Very big news. So my first article is actually a press release titled Diligent Acquires Spark Compliance, a leading compliance and ethics consultancy. So yes, my friends, my company, Spark Compliance, is now to be known as Spark Compliance, a Diligent brand. And I got to say, I started Spark in London nearly 10 years ago. It was just me in my apartment, totally undercapitalized with a dream and this book that I was about to have published, ready to go. Honestly, I could not have dreamed then about being acquired by one of the largest software companies in the GRC industry. I didn't know this, Tom, until we started talking more, but Diligent has 25,000 clients and over 1 million users. So it's huge. And I could not be prouder of going through the entire entrepreneurial cycle. Tom, I went to the Goldman Sachs 10,000 Small Businesses last year, and we talked a lot about exit and exit strategies, and getting to do this whole thing with Diligent. I think we can be quite a force in the compliance world. So I am the new vice president and head of compliance advisory services division. Along with all the Sparkies coming with me, we'll be in a whole new world of places to help with advisory, meeting with Diligent's great compliance solutions. So it is a very exciting time to have crossed over into this new world.
I'm excited for you. I have worked with Diligent over the past several years, so I knew about their size, scope, and that frankly, they needed exactly what you and Spark have. So I think it's a great marriage. I can't not be happier for you. I remember when Compliance Kristy burst on the scene, and it was just her. And now the Sparkies. And so I can't wait to see what you guys come up with next.
I am excited for it too. All right, Tom, let's go. What was JPMorgan's huge mistake?
So JPMorgan either made a self-inflicted mistake or they were defrauded. And whichever it was, they managed to persuade the U.S. Attorney for the Southern District of New York to bring criminal charges against a woman who sold them her company. And her company is or was called Frank, and it was designed to help lower and middle income families apply for student loans, grants, and scholarships. It claimed to serve millions of people, and either that was incorrect, that was fraudulently put to JPMorgan, or JPMorgan did insufficient due diligence to test these numbers that Frank had. Excuse me, I'm about to have a huge sneeze.
No problem. It is very confusing that the company is called Frank and she is not. I did find that tricky as I was reading through this article.
Or not. At any rate, it really brought up, even at the time, Kristy, it was very intriguing. Number one, and the woman they bought the company from was 27. How could a 27-year-old defraud JPMorgan, for multi-millions of dollars because the sale of her company was for multi-millions of dollars. She basically either created a list of fraudulent customer touch points, or she data mined in a way that was inconsistent with the way JPMorgan looked at customer touch points. And maybe it was relationships, maybe it was total reaches. Some platforms talk about total reaches. YouTube has a very expansive number that I'm not quite sure what it means. I know what a download means. I know what a view means, but kind of your exposure is 10 to 20 times that. But YouTube puts that number out. Is what she did fraudulent? Was what she did criminal? Or did JPMorgan just not perform adequate due diligence? And the lesson I tried to draw when the original deal fell apart, and it fell apart very shortly after it was signed, was that you still got to do due diligence on acquisition targets. And I'm not telling you anything that you didn't go through, I'm sure, in great detail over the past few months. It's still buyer beware. Yes, we have laws against fraud, and no, you're not supposed to create fraudulent numbers. And it's not clear to me if the owner of Frank manufactured fraudulent numbers or just took a very expansive outreach number that she had data scientists come up with. And JPMorgan didn't pick up the phone and call people and say, hey, have you looked at this service? Are you using this service? Have you downloaded anything from this service? That's the responsibility of the purchaser. And that's kind of one part of this. But the second part, they brought criminal charges, or the Southern District brought criminal charges against her. And is this really a criminal case? We talked about last year Mike Lynch and the attempts by HP to bring criminal charges against him for HP's acquisition of autonomy. And he got off. He got a not guilty verdict. And so why is JPMorgan going after this person? It's really their fault because they didn't do due diligence. I'm sure she's going to have a robust defense, but if JPMorgan was really pushing the prosecution on this, I think they've got another set of issues to have to deal with at trial.
Yeah, I mean, look, when I think my company is not large. Now, granted, it was bought by a company called Diligent, right? Due diligence. So they, as you might imagine, were very interested in making sure that they did everything that they could. So when I read about this with JPMorgan, my response was, how? But it also said in that article that it was bought via auction, which I thought that's interesting in and of itself.
Kristy, one of the biggest stories of the last news cycle has been about the executive order pausing FCPA. And I know we both were interested in it for a variety of angles. So I think we might spend a few minutes talking about this. You want to sort of tell us what we need to know for the start?
Yeah, absolutely. So this is probably maybe even bigger story than us being acquired by Diligent. I'm not really sure, but it was the executive order heard round the compliance world. So in case you've just joined compliance in the last couple of days, I will go over the highlights. So Pam Bondi is she's the new head of the DOJ. She signaled that she would not be interested in prosecutions for focusing on FCPA enforcement. Just for anybody who doesn't know, that's the Foreign Corrupt Practices Act. And it was basically what created compliance sort of 20 years ago. The compliance department came out of this. Not content with the DOJ's statements, the White House issued an executive order ceasing enforcement of the FCPA in general and instructing the Department of Justice not to continue with existing investigations except under certain exceptional circumstances. They're going to review what they're doing there. But also what I thought was really interesting here, Tom, was the quote, to determine whether remedial measures with respect to inappropriate past investigations and enforcement actions are warranted. For me, one of the big questions is, are we going to go undo some of these FCPA prosecutions? Are the people in jail for bribery going to be released? There is so much fear going on in the industry about this, what this means for our programs. Tom, what is your take?
So I am going to quote the person who I think is the top commentator of all compliance. And that, of course, is Wei Chin. And Wei Chin said, let's view this as an opportunity. and let's view this as an opportunity to up our game. And I absolutely believe that. Now, compliance has the opportunity to stand on its own as a business process. If this order had been executed in 2010, you and I wouldn't be on this podcast because the nascent compliance community wouldn't have coalesced the way it did in response to robust FCPA enforcement starting in 2008 and going forward for the next 15 years. Since that time, companies have developed compliance and ethics programs as a response to robust legal enforcement. But it's moved so far beyond that, Kristy. It is moved to investment. If you want to unleash the cash in your own company and you want to go on the stock exchange, you have to have a compliance program. If you want to go public, you have to have a compliance program. If you want to get PE money, you have to have a compliance program. If you want venture capital money, you have to have a compliance program. If you want a bank loan, you have to have a compliance program. If you want insurance, you have to have a compliance program. And the topper of all toppers is companies require the companies they do business with as subcontractors to have compliance programs. I still do work in the energy industry, and I still represent companies with a $30 to $50 million valuation, and they have standard contracts that require them to have an FCPA compliance program, and they've never been outside the United States in their life. And the business-to-business response to robust FCPA enforcement starting in the first decade of this year was to create compliance programs. Now, those compliance programs are embedded in your business. Wei Chen said, let's talk about ethics and compliance. I want to talk about innovation and compliance. I want to talk about moving from ethics and compliance risk to risk because compliance is uniquely situated to manage risk. What does a compliance officer do? They assess risk. They put together a risk management strategy. They train on that risk management strategy. They implement that strategy. They monitor the results of that strategy, and they improve as appropriate. That's the risk management strategy that every compliance officer does and engages in. They can do that in their head mentally. They can do it formally on a written process, but that's what we do. And if we can take that process and show management, this process works for any risk. It can work for an anti-corruption risk, certainly, AML, export control, data privacy, data protection, cybersecurity, you name the risk. But it could also work for a business risk. And I point to DeepSeek about a month ago, literally a month ago today, as we're recording this on February 20, which stunned the world by announcing they had developed a generative AI at 1/20th the cost of ChatGPT, or that's a business disruption. And that means if your business model is to get billions of dollars in investment and invest to come up with a product, and somebody does is at 1/10 or 1/20th of that cost, you've got a real business competitive problem. That's called risk. And how do you manage that risk? So I see compliance as having a great opportunity. And this week I'm writing a whole blog post series on what can you do at little or no cost to up your game now? Well, what can you do next week? My blog post series is going to be on how to use AI to up your game. Let's change the conversation in compliance to not anti-corruption compliance, but risk. Every compliance professional can change their vocabulary and change their discussion around the process of risk management to demonstrate to senior management and the board of directors that what you and I and everyone in our profession has done literally for the past 15 years, we can take that in a business process format for any risk the company has. So I think Wei Chen is absolutely right. This is a great opportunity. If you want to take the stick approach, you better show your value to senior management. I'm going to talk about that till I'm blue in the face because I believe we're at an inflection point, and I believe it's a great opportunity for compliance professionals, irrespective or irregardless of what the DOJ does, whether they suspend FCPA enforcement, whether they undo settlement actions, whatever they may do. We can show our value to the corporation, and we can move forward as leaders in business process.
Yeah, I think that's all valid. I also think that from my own lawyer perspective, the greatness that has been bestowed on us in terms of expansion from just FCPA, from third parties being all about bribery screening to, frankly, longer statute of limitations, which I think do help us, right? If you're talking to people in your company who aren't all on board with compliance and ethics, then you still have this 10-year now OFAC statute. Yes, maybe for the next 4 years, there isn't going to be FCPA enforcement, but the law still exists and violations of it can still be prosecuted later, whether or not they're being prosecuted now. Many of us have privacy as part of our remit. We frequently have modern slavery and human rights and human trafficking obligations that we're dealing with. So I think that one of the gifts is that it's not just FCPA anymore and that people don't think that it is. And the other thing is you picked a second article. We both picked articles on this, as you might imagine, because it's a big deal. And Joe Murphy talked about this a bit too, the godfather of compliance. And he talked about how companies paying bribes is an expense nobody wants. And that if we decide that everybody can try to get bribes out of American companies, that's actually a really bad outcome for the company itself as well. And where there's a quote from an expert called William Garrett in your article that you picked, and he said, quote, "It's kind of the same idea like you don't pay kidnappers, right? Because it just emboldens kidnappers to keep doing it," unquote. And I think there is something to that if we're talking about value of compliance is very important, obviously. But there's a second layer to that, which is these are unnecessary and unhelpful costs. So maybe it isn't useful and making American companies more competitive, which is allegedly the reason for this executive order. It's really not good business practice and isn't going to help you in the long run. So I think those are valid points and things to remember as well.
Absolutely.
Okay, so let's keep talking about the fun of what's going on with the government. With Mayor Adams of New York City. See, as Tom just said, we are recording this on February 20th. Who knows what will happen in the few hours before this actually gets published, because this is changing all the time. What's going on there, Tom?
Mayor Eric Adams was indicted by a grand jury in New York last summer. Charges were brought in the Southern District of New York. The charges were going to trial in April, and it was going to trial before the New York mayoral election of 2025. The new Department of Justice wanted the charges dropped. They ordered the then acting director of the Southern District of New York to withdraw the charges. She refused and resigned. Her lead investigator refused and resigned. Then the number two at the DOJ, Emal Bove, instructed a group of 10 or 15 DOJ lawyers that one of them had to sign or they'd all be fired within an hour. One of them agreed to sign. And so the government filed a motion to dismiss. In his correspondence with Ms. Sassoon, the now former acting head of the Southern District of New York, he said that charges were not being withdrawn because the facts were insufficient or the law was incorrect. In fact, they said they didn't review the law and the facts. This was being done simply to pressure the mayor of New York to toe the line on Trump's immigration policy as a quote, quid pro quo, end quote. That is not only antithetical to U.S. jurisprudence, but violates internal DOJ policy. So we had that set up. And then yesterday, we had an extraordinary hearing in the district court where the charges were filed, where the government and the defendant both asked and urged the court to dismiss the charges, and the court probed as to the legitimacy of the dismissal. Emal Bove testified under oath that there was no quid pro quo, even though he had said so, and even though the mayor had acknowledged that in a Fox News appearance literally 2 days beforehand. And they told the judge that the judge had no choice. He could not consider evidence or testimony from outside the pleadings that were filed. I don't know why they said that. I know why they said it, but obviously that's not correct. And so the judge is going to make a determination of whether the charges will be dismissed or there'll be any further hearings. I would note that a group in the state of New York has now moved for Emal Bove to be disbarred based on his conduct in all this. And where we stand is, as of the recording of this podcast, is motion to dismiss has been held, hearing has been held, no ruling by the court on this, and I think 8 lawyers from the Department of Justice resigned over this issue.
What a mess. Yeah. It was interesting because there's a mayoral election in the Knicks, as you've noted, in 2025. But from everything I read, I think it was the New York Times, I can't remember which one of them, wrote an op-ed that said there will be backlash here. Because New Yorkers that I know, certainly, and the people that I see, they do not like this. New York is a place where you don't want your mayor engaged in bribery and bribery charges. And also, whether or not you want to think it's a quid pro quo or not, the fact of the matter is people don't tend to like that as well, especially when the pro quo is going with immigration, what was a sanctuary city, right? In immigration enforcement. I kind of see this as a lose for him because he's not going to be reelected. And so maybe it's better to not be under bribery charges, certainly, than that. But it's just not a good scene for him. We'll see what happens there because we've been following it. It's been fascinating and interesting, especially the charging documents, but we'll see what happens. Shall we get to another mess?
Absolutely.
Okay. This is the messy edition. Some relationships have that on again, off again pattern, right? Mostly, you're probably thinking I'm talking about romantic relationships or friendships gone awry, but no. In this case, we are talking about the romance of the government with the Corporate Transparency Act. This on again, off again act is back on, at least as of this recording. The regulator at issue is the Treasury Department's Financial Crimes Enforcement Network, which is usually shortened to FinCEN. The Corporate Transparency Act requires millions of small businesses, including those owned by me, to register the ultimate beneficial owners of the company with the government. Mine was done several months ago. Previously, a judge in Texas issued a universal injunction against the law. The injunction was taken up by the Supreme Court for review, and the Supreme Court stayed the injunction, meaning that the Corporate Transparency Act was back in business. Although I tried to look it up, I didn't realize they didn't say why they ruled the way that they did, but they sided with the government. So in light of that ruling, a federal judge in Texas ruled that the law is in fact in force. Companies now have until March 21st to file their paperwork. Otherwise, they could face fines and owners could go to jail. Tom, crystal ball, is this the end of the battle, or is this thing going back up to the court for a full opinion? Where do you think this is going?
The most propitious comment I have heard about this set of events, as you have detailed, Kristy, is I have to go to my chiropractor because my back has been thrown out so many times. And so the injunction went to the Supreme Court. It was overturned. There's a second injunction, also in the great state of Texas. And this week, that judge voluntarily withdrew the injunction, the universal injunction. I think the injunction is still in place with the named parties. What's too concerned about that? We've also had several other district courts rule that the act is constitutional. But what we now have is actually kind of the regular situation, Kristy. It's winding its way through the courts. We have not yet had a Court of Appeals ruling. The initial case which found or held the CTA unconstitutional was out of the Northern District of Alabama. That's the 11th Circuit heard argument on the case in the fall, but has not ruled yet. So that's the First Circuit which will rule. But several other cases have been adjudicated at the district court level because it's generally been done on a motion for summary judgment on the unconstitutionality or not of the act. So we have a very big law, very significant, of course, within the compliance community because it's AML compliance, and it's winding its way up. But the reality is now that the injunctions have been stopped, we will probably have no more. I can't believe a district court will issue an injunction now, but we'll just have it wind through the courts until probably next year before the U.S. Supreme Court. Now, you did mention March 21, and that is a real date. And unless that date is, as of, once again, the recording of this podcast, it's not stayed. Perhaps me and others may have to actually finally do that filing that we said we were going to do. Maybe. I don't know. Nevertheless, there's a deadline of March 21 for the filing, whether Treasury keeps that or not. We may be talking about that in another podcast, but now we're just getting the sort of regular path to the Supreme Court. Probably won't get there till next year, maybe 27 when they actually get to it. Who knows? I think I'm going to have to go to my chiropractor and get a back adjustment.
let's talk about some more challenging places where there's whiplash right now. What's going on with China and McKinsey?
McKinsey, we had an article, I think, from Forbes about McKinsey and the discussions they're having internally about should they do business in China. And I really want this to lead, Kristy, a discussion that we would have about what is risk, how can you manage risk, or can you manage risk, and what are some of the things in this, under the current Trump administration, the dynamicism of relationships, of tariffs, of other rules and regulations that a company needs to consider. So McKinsey's having the basic discussion, is it worth the potential risk to be in China? And I say potential risk because we obviously are a competitor, a business competitor to China. Is that going to move to a more nefarious relationship? Is that going to scale back? Are there going to be tariffs? There are numerous Westerners who have been arrested in China. You want to put your senior execs or workforce at risk. I've drug up GSK in China, which was 2013 and 2014, where GlaxoSmithKline, the UK pharmaceutical giant, paid a $500 million fine and had their country manager and his direct reports all convicted of bribery and corruption under domestic Chinese law. This is not FCPA. This is not China extraterritorial law. This is China saying, we have laws that say you cannot bribe our government officials. Every country has one of them. And I want companies to have that risk discussion, Kristy. I want them to start looking at, this is a very dynamic situation. What about Taiwan? What about Pakistan? What about India? Wherever it may be, have that discussion, because you may have to shift literally over a weekend. And are you ready to make a business pivot if you have to? And the only way to do that is to have planned beforehand. So I applaud McKinsey for having these discussions, and I applaud them for letting us know about it through good reporting, because it's an important conversation I want compliance professionals to have. Everyone knows I've come out of the energy industry. We've been in China since the 80s or 90s, and I really worry about U.S. companies that have offices in China and what might happen to those employees.
Yeah. The thing that struck me about this article most was the statistic that they published from the American Chamber of Commerce that a record 30% of companies with business in China are considering or already have moved some or all of their operations out of the country. Savvy listeners will remember that we talked about friendshoring, which is one of my new favorite words, which was a Wall Street Journal discussion about moving supply chains out of countries with such volatile relationships with the United States into other places where they feel like there's much less likelihood of a either proxy or real kind of war. And so I think that you're right. I think anybody who's not having discussions or planning about what to do if their supply chain comes from China isn't paying attention enough. And also, there's every possibility that the Uyghur Act, which is about the Xinjiang province, we've heard a lot about those people potentially being, or allegedly, being moved to other parts of China. And I think that there's real risk that we end up with a lot more enforcement of that act in a broader way where you can't get goods into the country. So I think that they're smart to think about this and to do a cost-benefit analysis of what it's going to take to stay there or to leave.
Absolutely.
All right, so let's get out of the geopolitical messes and go to a survey that LRN has done recently. And Tom and I both picked articles looking at this as well. I picked the one from our friend Matt Kelly at Radical Compliance. And in his post, he dissects the LRN's annual compliance program effectiveness report from the point of the growing chasm between what the C-suite and senior executives think about the company's culture and commitment to compliance and ethics versus what other people think. Now, it is not surprising that the C-suite thinks that they're more ethical than regular employees do, but that chasm is getting larger and larger. Take, for instance, the example of the finding that 75% of C-suite and executive leaders believe managers hold themselves to the same standard as everywhere else. The warehouse and factory workers found that 42% of them thought that they were held to the same standards as everyone else. So that is a 33% gap in those perceptions. The study also found that there was growing disconnect between how managers feel about things like fairness within the organization. So what do we do about this? Matt had some interesting ideas, including performing focus groups at manufacturing locations or retail stores with the non-salaried employees and bringing those types of employees in to ask them what they'd like to see in the compliance program. Do they understand the training? Do they understand the policies? Getting feedback from the ground. So lots of interesting stuff here, Tom. What caught your attention either in the survey results or Matt's analysis? What do you think?
I think it's just this basic disconnect, Kristy. And we talk about tone at the top is one of the most ubiquitous phrases in compliance. And then we talk about how you've got to not talk the talk, but walk the walk. But I think this points out we're not completing the conversation. The conversation needs to say, this is a two-way communication street. It's communication down, certainly, but it's also communication up. And if there's a disconnect, management needs to know about that disconnect because it's they're going to be them on the line if there's a failure. And we need to be able to get that information up. And it really speaks to the need for communication backup to senior management to close this gap.
Now, you took on a different take on this from a different article. What did you find interesting about that review that they did?
That review told us that, and came to us a little bit rather from Forbes, and I think it was the same study that Matt talked about, but it focused on the LRN study, and they quoted our mutual friend Ty Francis in this study, and that we need to have not only this gap, but there's a generational gap and a geographic gap. And by that geographic gap, the United States and the EU and the United Kingdom. And part of this ties back to our prior discussion on suspension of FCPA enforcement and whether the government's going to either allow or actively encourage U.S. companies to engage in bribery and corruption. I think you kind of hit on this, which is employees don't want to work for companies who break the law, and they don't want to work for companies who engage in bribery and corruption. And we saw that in 2008 with Siemens. Siemens employees did not want to be known as working for a corrupt company. And so Ty and LRN posited that there will probably be a bigger push for enforcement from the EU. And that would not surprise me one iota. And how it ties back into our earlier discussion is every multinational company does business in the United Kingdom and EU. It's the second biggest trade market in the world behind America. And so you're going to have to comply with their laws. And if you follow the Trump prescription, you're going to get into big trouble. And you're going to raise another risk, or two other risks, reputational harm and damaging your relationship with your own employees.
Yeah. I also thought it was interesting that they found that the Gen Zers were the least likely to trust their managers. And I think that's a really interesting thing because they are going to be a stronger and stronger component of the workforce. And they have really, as a group, some very strong values. So I think they're going to vote with their feet. And that's going to matter because when talent walks out of the room, that's a really big problem.
Indeed, I talk to a lot of HR professionals, and they almost all say to a person, the two biggest issues for a corporation will be talent acquisition and retention. And if Gen Zers don't believe in your corporation, they won't be retained, but they'll move on.
They will. Shall we end our very interesting episode with Florida?
Absolutely. What do we have with Florida woman this week?
Florida woman, I know, right? So this time we are dealing with Florida woman whose youthful good looks did not stop her from her run-in with the law. 44-year-old Florida woman Veronica Torres allegedly used her mother's identity to fraudulently apply for hurricane aid. Because Miss Flores did not live in the pathway of Hurricane Milton, but her mother did. Miss Torres took her mom's name, driver's license, and social security information to make an application for aid. When she arrived to pick up her $8,000 check, the savvy government employee queried why she looked so much younger in person than she did on her mother's driver's license. Her answer was Botox. Botox took 30 years off her age, which is just incredible. Now, the employee told Ms. Torres to come back the next day to collect the check. She called the police, and Ms. Torres was brought in for questioning, ultimately charged with a third-degree felony count of filing a false public assistance form. It goes to show you, Tom, Botox can smooth wrinkles, but not criminal records.
Kristy, we were complimented this week by, and now I can't remember who, someone who told me that when they stumbled across Florida Man on our podcast, they were absolutely thrilled. Their only advice was, we need to change the title to Florida Person.
Yes,
because it's both true. Florida Man and Florida Woman. So they said, just wrap it up. And at some point I'll dig this out and put it in the show notes, but there's a website that allows you to enter your birthday and date, and it will give you all of the Florida Man or Florida Woman reports from that day. So we may have to do that for our respective birthdays in 2025.
Oh man, birthday edition. It's coming to you. In the meantime, make sure that you keep listening to the Two Gurus Talk Compliance podcast. I'm Kristy Grant-Hart.
Of Diligent. And I'm Tom Fox.